Good afternoon. This is a pre-examination meeting into 9 way leave applications in relation to property between Kendoon and Tongland in Fries and Galloway. My name is Polquhanity, and along with Katrina Rice, we are 2 Scottish Government reporters who are appointed in relation to these various applications to consider and report the objection have been received in respect of each landowner for the way leave applications for the installation of electricity lines at Kendoon to Tongland. Katrina Rice has been appointed in relation to a related application under Section 37 of the Electricity Act. We are both jointly appointed in relation to these matters, and I am the lead reporter in relation to the way leave question. The applications were made under the Electricity Act 1989, Schedule 4, and by objecting landowners to be heard before we report to ministers making recommendations in relation to the applications. An application for a way leave under the Electricity Act requires the applicant to show that the permission should be granted by way of a necessary way leave where it is shown to be necessary or expedient that be granted. Our purpose is to report to ministers on whether that test of necessity or expediency has been met in relation to each of these cases separately, and ministers will then consider accordingly. As I think we've written out to you in previous correspondence, the procedure is under a rather elderly set of rules dating back from 1967, the Electricity Compulsory Way Leave Hearing Procedure Rules 1967, with some modifications to reflect more modern conditions since then. By way of general introduction, I would say this pre-examination meeting is being recorded, and accordingly any parties who are watching it can access it at a later stage if they want to refresh their memory as to what's happened at the meeting and what was agreed, although a note of outcomes, a note of the meeting will follow in particular action points and deadlines that are identified. Participation in the meeting is taken as agreement for data protection purposes to the use of the recording on the DPA website. As a pre-examination meeting, the only procedural matters are being addressed, and I think all, or certainly most of you, have had a chance to see an agenda of the meeting ahead of time. For those that haven't, that's being circulated as we speak. But for a meeting of this nature, it's only procedural matters rather than substantive matters that will be addressed. For a meeting of this nature, I'm conscious that for some of you, this is an unfamiliar process, and although there's a degree of formality in the reporting process that myself and Katrina will be undertaking, we're keen to make this as informal as we can, both for today and in subsequent procedure that's required to be carried out. And so if anybody who doesn't have the advantage of legal or other representation should certainly feel if there's anything that they don't understand or feel uncomfortable about any of the processes or aren't following, they should just feel free to say, and we'll try to make this as easy a process as you can for participation in this. I'll start perhaps by maybe asking, starting with agents for the applicants, just to introduce themselves and go around the room to, if people could indicate who they are and who they represent, and starting with Murray Thompson.
Thank you. I'm Murray Thompson. I'm a partner at Shepherd Wedderburn, and I'm acting for SP Energy Networks in respect of the necessary way leave applications.
Okay, thank you. And then I think Matthew Sinclair, if you can bring you in next.
Yes, Matthew Sinclair. I am the owner of Knocknarling Estate, Knocknarling Farms, over which this part of this way leave runs.
Okay, thank you. And I think you have an agent. I think Mike Reid acts for you from Galbraith, but he's unable to attend the meeting today. But he, I think, is an agent on your behalf, and will continue, obviously, to communicate with him subsequent to this meeting.
That's correct, and he sends his apologies. It was a clash of appointments.
Okay, thank you. And James Anderson.
Hello there. Yeah, James Anderson here, owner of Waterside Farm at Dalry, which is owned by my company, Turbine Repair Solutions. The part of the way leave is regarding some access through a field of ours.
Okay, thank you. And invitations were also issued to Mr. Phil Speckleson, acting on behalf of his mother and other interests in relation to his property, but also Irene McCreath. We were expecting Mr. Phil Speckleson on the call, and he may join the call, but we've had no indication as to whether Ms. McCreath is intending to attend this morning. I think it might be useful if I maybe set out my understanding of where we are on the WAY-10 and our 9 way leave applications, to summarise where we are, and then give some consideration as to what procedural matters there are that we need to be addressing this morning. Before I do so, I wanted to just address one specific question to Mr. Thompson. I'm very much assuming, for the purpose of this, and I know that there's a read across, not all the objectors are objecting to both, but there's a read across to the Section 37 application in respect to which Katrina is appointed. I'm assuming that the applications for the way leaves are entirely dependent on ministerial approval in due course on the Section 37 application, and so that in the event that the Section 37 was refused by ministers, the way leaves would fall. I just wonder if you could, just for the record, just explain that interrelationship, just so I can understand what the role is that I, along with Katrina, will be carrying out in relation to the way leaves, need to understand in terms of our reporting process.
Yes, I mean, obviously, there are distinct legal processes. However, sure. I think your analysis is correct in the sense that they would be determined at the same time, and if consent was not granted for the Section 37 and deemed planning permission, then we would not expect that the test of necessity or expediency would have been met, and therefore the necessary way leaves would also fall. Okay,
that's helpful. I don't know if others on the call want to say anything about that particular aspect. We'll come into a bit more detail of it a bit later on.
Can I just ask, the section 37 is, just so that I'm clear, is dealing with the overhead power line. Is that correct?
Yes. I mean, I'll defer to Katrina, who is the sole reporter in that case. That's my understanding. But she's certainly nodding, but she might want to just confirm.
Yes, there's 5 overhead that it will deal with.
I'm sorry, I missed that. I missed a bit of that.
You just said 5 and we lost you for a wee bit.
All right, there's 5 overhead lines that I will deal with in the Section 37 case.
Yeah, okay, and that's, just so that I'm clear, and that's the Section 37 the case or application. Yep.
It is, yes.
Yeah. Okay. Thank you.
Okay, Mr. Anderson, is there anything you want to say on this particular question?
No, I understand what you're saying. If in basic terms, if the overhead line doesn't get permission, then the way leaves will fall to one side and not be required. Correct.
Yeah, that's just seeking confirmation. I think that's right. So we are jointly appointed in relation to now 9 outstanding applications. And Mr. Thompson will keep you right if I'm not narrating this correctly. 2 have been withdrawn. There are 3 that are assisted, and I don't know if, Mr. Thompson, you've been checking your emails over lunchtime, because there was one in which there's a bit of communication this morning in relation to St Johnstown and Dalry, where there was some late correspondence, but we have had confirmation from the landowners' agents in that case, Ms Burnett, who has confirmed agreement, and the letter may not have quite come out yet, but assist has been indicated in respect of those cases. So that brings the number which are assisted to 3. For the benefits of others on the call, assist is a legal term which simply means that the case is put in abeyance, is kind of held in suspension meantime, when no further action takes place in relation to any application, and it can be assisted for a whole number of reasons, but that no further steps will be taken until the assist is recalled, as the phrase is. So for three of the applications, they've been deemed assisted. We have one application where there's been an objection. This isn't one, Mr. Van Sprenkelsen. He maintains his objection. He's asked for a hearing. He is also an objector to the Section 37 applications, but as yet we've received no statement of case from him. We've received a statement of case on behalf of SP, but we've not received a statement of case in relation to Mr. Van Sprenkelsen's interest. I asked that if he was able to do so, he should issue that by today, and certainly checking it around an hour ago from our office, it doesn't appear as if that's been received. So that's the position regarding Mr. Van Sprenkelsen. Is that a correct summary of that from SP's point of view?
Yes, that's correct.
Okay, and then for Matthew Sinclair, again, you're maintaining your objection. I think you've not asked for a hearing, but you're not an objector as such to the Section 37 application, and we have received a statement of case from you, and SP have issued a rebuttal to that, which hopefully you've seen, and I think was copied to you. But given that the issue that you had with the agenda, you can maybe let us know if for any reason you've not seen Scottish Power's rebuttal to your comment. But that is that a reasonable summary of where you are on this case?
Yes, that's sorry, there's a lot of feedback there. That's a reasonable summary. Just on your point about have I seen Shepard and Wedderburn's response, it was sent to Mike Reid. I have got that, but I haven't. It came through to me. I picked it up yesterday or the day before. I haven't read it yet.
Okay, no worries. That's fine. Well, that's okay for the purpose of today, because, as I say, there's no, we won't be talking about anything of substance in relation to those issues. But there is one question that we'll come to in a moment about the interrelationship, nevertheless, with the Section 37 applications. The eighth case is in relation to Mr. Anderson, who I think is the turbine repair solution, where he maintains his objection. He's asked for a hearing. He's not an objector to the Section 37 application, but according to our record, we don't have a statement of case from Mr. Anderson. So if I may just check with Mr. Thompson, first of all, does that seem a reasonable summary, then go on to Mr. Anderson?
Yes, I've seen nothing so far. No idea of what the particular concerns are.
Yeah. So, Mr. Anderson, is that a reasonable summary of the position so far from you?
Yes, that's correct. Yep.
Yeah, I mean, I would emphasise the importance of ensuring that your statement of case is lodged, partly from myself and Katrina's perspective, in understanding what your grounds of objection are, and obviously from in order that we can work through along with the applicants to get a sense of what your concerns are, and that can allow a kind of focus when we get to the hearing, which I'll come to the detail of it in a moment, as to what how we address those and how we take that forward. So it would be useful if, as soon as you reasonably could, you were able to lodge that statement of case, and some of the discussion we have later on this call will be subject to what emerges from all of that, because I want to talk a little bit in a few minutes about how we deal with the practicalities of having a hearing in your case. And at the time we get to the hearing, we'll certainly need to have seen what your statement of case is, so that there's kind of no surprises either for me and Katrina or for the applicants. So that's quite an important part of the process. So, and then the ninth application is Irene McCreath's, who maintains her objection. She's indicated she doesn't want a hearing. She's not an objector to the Section 37 application, and she's also submitted no statement of case thus far. And again, to Shepard and Wedderburn, is that a reasonable summary of that and all other cases?
Yes, that's accurate.
Okay, that's fine. Right. Hopefully that's useful as a sort of a general preamble to discussion today. Item 2 on the agenda was an update in relation to this morning's pre-examination meeting regarding the Section 37 application, which neither James or Matthew were in attendance of. I had some, most of it ultimately on my phone. I thought at one point I'd be doing this call on my phone as well, but fortunately I've been able to avoid that hazard. I heard a little bit about provisional possible dates for the public inquiry in relation to the Section 37 application, and also some representations in relation to whether it be held virtually or in person. I'll maybe ask Katrina if she wants to summarise the kind of key aspects of this morning's meeting that are relevant to our agenda this afternoon.
Yes, I'll just give a brief summary of what we're doing. Bit of feedback. Can everybody hear me now?
Yeah.
Yes, so a summary of what we did for the Section 37 pre-examination meeting. So we talked about the general purpose of the meeting, my provisional assessment of the main issues to be addressed and those requiring further procedure, the participation of interested parties in those further procedures, the hearing of evidence, the dates, location and likely duration of the inquiry and hearing sessions, the procedures for the inquiry, and also about site inspections. Now, the most important point to note is that provisionally dates we spoke about starting on the 24th of October and progressing until the end of November, possibly. I will provide a definite date within the note of my meeting, which I hope to issue week beginning the 27th of June, and that will be available on our website for anyone with regard to the way leaves who wants to look at it. Those were the main things that came from the meeting this morning, but my note will explain in more detail everything that was agreed. Okay.
And can we make sure that that note also goes to the attendees of this call who weren't at this morning's meeting, because that might otherwise, they might otherwise fall off the copy recipient list. That's probably quite a useful thing to see. Do any parties have anything they want to say or ask Katrina about this morning's meeting that are relevant to their interests for this afternoon? Shepherd Wedden, first of all.
No, nothing.
And objectors?
No, I've got nothing to say at this moment, but I'd be interested to see the note of the meeting.
Okay, and James?
Yeah, I'd be the same. Okay now, but it'd be good to see the note from the meeting this morning.
Okay, thank you. Now, the next item on the agenda was the issue in relation to the outstanding way leaves of the conjoining of the various issues. Now, Mr. Van Spreckelsteen, who's not on the call, had objected to conjoining, and my intention at this point was to ask him to speak a little bit more about what his potential objections might be. That's obviously not going to be possible with him not on the call. It may be this is less of an issue now, since subject to the outcome of the assisted cases, there are only 4 objectors, all operating in slightly different kind of ways, some with a crossover to the Section 37, some less so. But the advantages, certainly from myself and Katrina's point of view of conjoining the processes, is that if there are hearings, then we can consider the kind of the principle of the case from the applicants together, rather than making the applicants present cases more than once. The disadvantage is any one particular objector may have to sit through the objections from other landowners at a hearing when they've no particular interest in those things. The advantage for the reporter and the reporters appointed here as they, first of all, it makes the hearing process a bit more straightforward if there's more than one hearing. It also makes the writing process a little bit more straightforward, because if there are a lot of common interests, then writing one report dealing with all the different objectors in chapters is a little bit less cumbersome than it is writing other reports, one report for each particular case. But as I say, with Mr. Van Spreckelsteen not on the call, it's probably a bit bit difficult to take this point any further. I was going to slightly reserve my view, depending what he was going to say, as to how we go forward, depending on where the objections actually go. So I don't think we need to spend very much time on this. But I wonder whether, Shepard Wedderburn, have you any comments, particularly on the issue of conjoining?
No, I agree with the advantages that you've set out, and that's certainly what has happened in the past with new overhead lines, and for the reasons you say, the efficiencies that it drives, and some of the issues that really go to the heart of enjoyment of property will be looked at the Section 37 hearing sessions. And in terms of the one disadvantage you highlighted as that someone may have to sit through those, Mr. von Spreckelsen is already he's already volunteered that he is prepared to attend most of the sessions, so I don't think even that sort of disadvantage would apply to him. So he'll already be in the hall, and I think it's sensible that the necessary wee leave applications are considered after the sort of conclusion of the Section 37s. Yeah. Sorry, the necessary leaves are considered after the Section 37s. Yeah.
Okay. And I don't know whether either of the other landowners have any particular views on this issue. I know neither of you have expressed a view up until now, but if there's anything you want to say, feel free to say now.
No, I mean, I don't. I'm not familiar with the process of, and I would have to defer to those that are advising us to the benefits or not of conjoining. But at the moment, I've got nothing specific to say on that. But certainly that's something that I will take up with the advisors once they've been able to see the minute of the meeting. And
that's all fine. And James?
Yeah, I don't have a problem with it being conjoined. It's no problem.
Okay. That's fine, thank you. The next issue in relation to potential hearings and the like and the procedure relates to Matthew Sinclair's objection. And this is something that we wrote out to both those parties in relation to that. Having seen the statement of case and the Shepard and Wedderburn response to all of that, there's a range of issues set out there that will need to be explored in due course, but there's two specifically. One is relating to an objection to the route and a suggestion that the route of the way leave be different to avoid woodland and other reasons for that, and the suggestion that they proceed by undergrounding for the purpose of minimising the impact on the land concerned. Now, the issue that's in my mind is that these questions of the line of the route and undergrounding are capable of being dealt with on a kind of a one landowner basis, but there's a strong overlap with the Section 37 application, and I'm conscious that, Matthew, you're not formally an objector in that Section 37 process. So my question and my dilemma, and I maybe ask Mr. Thompson to give me his views first of all on all of that, is what's the best way in which we can explore those issues in particular? And as I say, we may be able to sever those from other objections in the case that's being made, but I'm slightly torn between the proceeding with a kind of bespoke hearing in relation to one area of land, when the question of undergrounding and the question of the appropriate route may well have implications both generally for the Section 37 application, but also for other landowners in other areas, and whether it's better to kind of roll that into the Section 37, even though Matthew's not an objector to that, or whether, for example, those issues should in the way leave should be sisted effectively until they're addressed in the Section 37 application. So there's a bit of a kind of an issue that I'm not sure about the best way to fairly and most expeditiously explore these issues. But Mr. Thompson, first of all, I don't know, as I say, we're giving you, I think, a forewarning that I was going to ask this question. I'd welcome your views, then go on to the landowner.
I mean, I think if if we are going to conjoin and the necessary way leave hearings are going to follow the Section 37, then I think even if the cases are set out in advance, then I think we could rely on the evidence that's been led through the Section 37 process, notwithstanding that Lord Sinclair has not actually tendered an objection to the application for the overhead line itself.
Yeah.
Alternatively, we could look at it on the basis that it really goes to the heart of whether the necessary way leave is expedient, because we would in the normal course we would consider whether there was a better way, a more expedient way of delivering the connection itself, and therefore, I mean, we've no wish to see him prejudiced because he's not actually, submitted the Section 37 objection. But I think we could rely on a lot of the evidence that will be heard through the routing session and the consideration of alternatives, which covers undergrounding and which will no doubt cover that particular section, despite the fact, as I say, that there isn't a standing objection to that, and then that should help to sort of truncate the consideration of those issues through the necessary way leave itself.
Yeah, I mean, I'm conscious that there's not been a request for a hearing in relation to the way leave aspect of things, and know that that's not necessarily a problem, because obviously there's documents exchanged as well as the hearing, so there's a bit of a quirk from that point of view. But go on to Matthew. How do you think that your kind of objections are going to be best aired on a kind of bespoke separate consideration, or as part of that wider consideration of those issues and part of Katrina's work?
Paul, forgive me. I mean, I don't know if I know the answer to that, because I'm not. I don't have the benefit of being as familiar as Mr. Thompson is with the process here. Sure. So, forgive me. The email that was sent by either you or forgive me, I forget who it was.
Officer, yes.
Only got to me late last night, and because I wasn't copied in on it originally from the case officer. So I'm at the moment I think I need to understand the implications of what of what is being suggested. I mean, so my question to you, would it make it simpler for you as a reporter if I became an objector to the Section 37?
Yeah. I mean, yes, that's another way of doing that. Now, that would require Katrina to consider, as she may give her view in a second, whether that's acceptable to her, because she's the reporter there. But yes, that would certainly be an option. Katrina, I don't know what you would think about that.
Yeah, the first thing I would do would be to ask.
Oh, sorry, I have to repeat that, Katrina.
Okay. The first thing that I would do is ask the other parties if they had any objections to you being joined as an objector in the Section 37 cases, and subject to that, then I would make a decision about whether or not you could be. But just looking at it from a simplicity point of view, it could make our reports easier to write, but I would have to ask other parties for their comments first.
Yeah.
So I'm I think if I may, maybe this part of it. So that I am fully understanding of the process of these two different processes and the implications, or the quirk that we've got here, whether we can have some time to ask those questions and to understand this a bit more, and whether that's taken offline or not, I don't. That's for a procedure. That's a procedural thing. So. If I can ask for that, please, whilst I understand and are able to take sort of specific advice on that.
Yeah, I mean, I don't know what Mr. Thompson thinks. That makes perfect sense. And one thing we could do, because we have done it with other cases, is in respect of this objection, simply assist this in terms of the way leave process for, say, a couple of months, in order to allow those other discussions to proceed kind of in tandem, and to do what Katrina has said about seeking the views of others and then expressing a view, making a ruling in that respect. And then that means we wouldn't kind of press on with too much of the consideration of the way leave application until that's resolved, and then come back, probably not in another meeting like this, but come back in writing and then decide next steps beyond that. But having, say, a 2-month cyst would certainly protect your position as an objector in the meantime. But Mr. Thompson, don't know what your views are.
I would have some reservations about allowing a further objection at this stage, because it could raise issues for others who may have wished to make representations or objections who have been denied that process because they felt that the opportunity had passed. But in terms of I've no objection to assist to allow further consideration of the issue. But as I say, I think expedience, even in a written submissions context, I think the expedience argument does allow Lord Sinclair to explore or put forward arguments that undergrounding would be more consistent with SP's statutory and licence duties, which I think is his position. And his statement is very, it's very helpful, because I think both parties are very clear on the respective positions, and that allows us to focus on the areas that are in dispute. But I think the sort of routing and the means by which the connection is to be made, I think can still be explored through the hearing statement, not hearing statement, a written submission through the necessary relief process. But as I say, quite content with a assist for a period to allow Lord Sinclair to take advice.
Yes, that makes sense, and it's obviously fair to him. And then as part of that process, maybe parties could give some thought as to what extent other aspects of the objection can be severed and can be dealt with separately, because some obviously will cross-refer, and I saw some references to protection, I think, of beech trees and various things, and there are things there that may be able to be dealt with not by conjoining, not by taking along with the Section 37 process, but allowing things, if the reporter agrees, to be taken in as part of that. I mean, obviously, you'll reserve your position until this is considered further by the reporter, but there's a degree to which it strikes me this is a bit of an exceptional set of circumstances. It's a slightly naughty with a K problem, and may just need a bit of imagination to resolve it. But maybe if we agree, and I can record this in the note of the meeting, that we assist the case for 2 months, and that we that Katrina in her case then takes forward the consideration and invites representations on that as a possible solution. How does that sound, Katrina?
Yes, that sounds fine, and I would intend. I think it's when you're on mute.
Right, I'll go on mute, and then that may help.
Yeah. So yes, I'd intend to do that over the next few weeks. So it wouldn't wait for the 2-month cyst. I'll be asking for parties' opinion possibly next week.
Right, that's very helpful. Does that sound okay from your point of view, Mr. Sinclair?
Yes, that's fine, and I think that that gives me a little bit of breathing space to understand the process and get some more clarity on where we are. So thank you. Yep, that's fine.
Okay, that's fine. And moving on to Ms. Anderson, we mentioned earlier about the need to have an indication in writing of your case. Now, you've not objected to Section 37, and you have asked for a hearing. As I say, it'd be quite useful to get an indication in writing of what your arguments are to give Mr. Thompson the opportunity to respond to that, and then work out what the next stages are in terms of the process. Because there's no objection to the Section 37 as such, and once we get that statement in, and you've asked for a hearing, I don't see an immediate reason why we shouldn't look provisionally to set a hearing date for that particular case, unless there's any thought that should not be before the hearing for the Section 37 application, and I don't immediately see the reason why not, because they're not related. But I don't know. Maybe start with Mr. Anderson. I don't know if you can give any indication as to whether what the sort of timescale is that you think you'll be able to produce something in writing. It can be quite informal and quite short. It just needs an indication in writing for my sake, Katrina's sake, and Mr. Thompson's sake, what your arguments are, and then from that it might be possible then to be looking to find a date to proceed with the hearing. But I don't know if you'd be able to do that, Mr. Anderson.
Yeah, I can certainly put something down in writing. In the next couple of weeks, it's not a problem.
Yeah.
The reason for asking for the face-to-face hearing was to avoid, kind of back and forward emails or whatever.
Sure.
I think it's quite a straightforward case that we've got, and I think it should be fairly easy to tidy up. But I certainly could put a written response. To a couple of weeks.
That'd be helpful. As I say, I want to keep this as informal as I can, but there's a degree of formality to it. And as I say, the applicants have submitted a statement of case on their behalf, and if I have one from you, and then they'll have an opportunity to comment on that within the 3 period previously given, then while it's possible that may give rise to other questions, I'd be reasonably hopeful that they would be the only kind of documents that set out what the parties' arguments actually are. So there shouldn't be kind of endless emails. And then if you can do that, then we can start looking at dates for a potential hearing on those issues, if that would be a feasible way forward. Before I go on to talk about what that hearing might comprise, Mr. Thompson, is there anything you want to say about looking to proceed on that basis, in that way?
No. I mean, it would be helpful from my point of view if Mr. Anderson was able to very briefly set out what the broad concerns are, because I haven't had that information so far. I mean, ahead of a sort of more formal statement in a couple of weeks.
Yeah.
Just from my own point of view, it would be helpful.
Well, I don't know if you're willing. You don't have to do that, but I don't know if you're willing to do that just now, Mr. Anderson. You still there? I don't know if you might be on mute.
Hello, sorry, if you're talking to me there, I missed everything that you said.
Yeah, sorry.
It was already frozen.
Yeah, Mr. Thompson was asking, he said it'd be useful to have an indication within a couple of weeks, just sort of setting out the grounds of the basis of your statement. He was asking if you're willing to, and you don't need to do this just now, just in order to help an understanding from his point of view, just to briefly set out what your grounds of objection are. As I say, you don't have to do that just now, but it would give him an opportunity to start thinking about some of the issues from their perspective.
Yeah, not a problem. I mean, the main objection is, they want to put a new access track in to the rear of our property, and the issue of there's an existing track already there within 100 yards of where they want to put it in, and they're actually wanting to reconnect to the original track, and I think it's utterly pointless to interfere with the field, and there'll be an extensive piece of like hedgerow that need to be taken out. There's issues with the layout of the road. There's a lot of like mature oaks and beech trees, and also birch trees in the area. And they would have to take a dike down. It seems a lot of work, which is completely pointless when there's a road already there, which I've indicated to the ASP guy that came out to the site that, I would certainly, be happy to discuss the use of the existing road, but obviously there need to be some kind of compensation for that use.
That's very helpful from my point of view. So it seems to be about the access rights. So that's very helpful from my point of view.
Yeah, okay, that's helpful. But if you're able to write that down and send it in to us and copy to Mr. Thompson, that would certainly help set that process going. Beyond that, it's probably quite difficult to say at this stage what a hearing would comprise and how long it's likely to extend for and when it would be. But it may well be on that basis, and we'll need to, in fairness to SP and their witnesses, need to avoid the dates that are ultimately set by Katrina for the Section 37 application hearing and inquiry sessions. But we can then look at having a hearing date perhaps sometime in the early autumn that might be appropriate for all of that. The only other issue I'd want to raise and just seek views in that regard is if we were proceeding to a hearing in relation to Mr. Anderson's objection, as whether parties have any preference as to whether they would want that to be an in-person hearing or a virtual hearing in a kind of a means such as this. DPA are generally moving, where appropriate, for hearings more towards virtual rather than in-person hearings. But the question might be related to the extent to which it's necessary for we as the reporters to come and do a site visit and see the site concerned, because if we're travelling down to see the site there, we're in the vicinity anyway, so an in-person hearing has certain advantages. But I don't know, I'll start with Mr. Anderson, because it's your objection on this one, whether you have any preference as to whether you want the format of the hearing to be virtual such as this, or would you rather have an in-person hearing in due course?
I would far rather have you come to the property and see my objections with your own eyes, and I think it will become quite clear. And you'll see why I'm objecting to the way leave. So that would be my preference.
Okay. I mean, we'll certainly would, if it's necessary to do so, would come to the property to see it anyway. We'd like you to do a site visit to come onto your land, obviously with your agreement, to get a proper sense of what the layout of the land actually is. That in itself doesn't necessarily mean that a virtual hearing is not an option, but you certainly have made that position very clear. Now, Mr. Thompson.
I think it would be more efficient to have the hearing in person, given that reference will be made to various documents, which I think it will be more useful to have in hard copy in front of us. And yeah. You'd mentioned a hearing in the autumn, but I had envisaged that any hearing would follow the Section 37 process.
Oh, for the landowners who are not objecting to the Section 37 process, there's no particular or obvious reason in my mind why they should be connected to one another. I mean, it certainly is possible, and it may be in practical terms more convenient for that to happen in that sense. But given that Mr. Anderson's not an objection to the Section 37 process, Lord Sinclair's point's a different one, and it may be different for him. I hadn't seen a kind of an automatic link between the two that would take it into that order. But it may be it's administrative convenience as much as anything else. I don't know where your preference is.
No, I think we'll have two hearings. One will be Mr. von Spreckelsen, and the other will be Mr. Anderson. And I think that a lot of without knowing the substance of both of the cases, I think it would be useful if a lot of the evidence has already been prepared and is in process and is before the reporters, that the necessary way-leaves would follow the Section 37 rather than in advance of that.
Well, one of the issues, of course, unfortunately, Mr. von Spreckelsen has joined the call, so I've been unable to tease out with him his views on conjoining. But the other set of questions I was going to ask him was the question as to whether, because he has asked for a hearing and he is an objector to the Section 37, whether his preference and indeed your preference would be that his hearing takes place in a kind of a discrete time slot as part of the Section 37 inquiry and hearing process on the dates to be considered by Katrina in those cases, or whether the preference would be to completely kind of separate it out from that and have it differently. Now, the separating out gives the option of virtual, but he did say this morning that his preference is not to have virtual. So it may well be that actually that one way of doing this is, if it could be scheduled around the Section 37, to find some time when all the parties are otherwise there and have both Mr. Anderson's and Mr. van Sprekelson's objections dealt with, in either in the same session, effectively conjoined, or consecutively. So it may well be that we're looking at the dates, and Katrina can maybe remind me if I've got the dates wrong for that. It's basically, I think, 24th October through to the end of November. And it may well be, if Mr. Anderson is broadly available around then, that what we look to do once decisions are made in that respect is to look to find maybe a half-day slot or whatever at a time, towards the end of the Section 37 inquiry. But Katrina?
Yeah, just to let you know that there was a period of time, if Mr. Thompson remembers, when the council said they were unavailable. Now, if I decide that I'm not going to impose the dates, that's a possibility, but I'll wait and see.
Okay, that's helpful. I mean, Mr. Anderson, is something around? Are you, as far as you're aware just now, are you kind of generally around if a hearing was fixed for sort of end October or sometime in November? Would that generally be an okay time period for you, or are there reasons where that's a problem?
No, I don't see it cause me any great problems. I have nothing written in stone for that period of time at the moment, so I can keep that clear. That's
fine. Well, we'll speak to you about exact dates and various things. But if you think you're generally clear, obviously you can't commit for every single day of your life. But if you're generally free, that may be a way forward for that. Sorry, Mr. Thompson, I think you're about to speak.
Yes, well, although the council was not available, I think the 2nd to the 8th, Mr. von Sprekelsen has indicated he will be participating fairly comprehensively, and I think it would probably be more useful to use one of the days which has been set aside at the end, because I think the 2 hearings shouldn't take more than a day, maybe a half day for each one, and we should use those, because there's no point in having evidence on the necessary way leave which precedes evidence that he's going to lead in terms of the Section 37 itself on visual. Well, it really depends on what the scope of his objections are, but I think a lot of the evidence won't have been led at that stage. So I think it would be more sensible to have the necessary way leaves follow the evidence on other local issues.
Okay, and Katrina, any further thoughts on that? That certainly seems to make sense.
I'm happy with either.
Yeah, okay. And that's fine. And the 4th objection, of course, is Ms. McCreath's, who's not asked for a hearing and hasn't lodged a statement of case, and so and is not in the call. So it's not really possible to reach a view on that. And it may well be, if she doesn't ultimately issue anything indicating her objection, then we'll just have to deal with that accordingly. But none of that should impact on any of the other conversations we're having about scheduling issues. And we as reporters will have to work out some way in which we report and decide the appropriate timescales. We'll obviously send her a note of the meeting from today reflecting that, but I'm not sure there's more we can do about her.
I think just for the record, we're pretty hopeful that one will be withdrawn.
Okay.
I think that there is an agreement, fairly well, in terms of an agreement at an advanced stage. So I'm hopeful that one will be withdrawn quite quickly.
Okay, no, that's helpful. Okay, thank you all for that. We've touched on it a little bit already, but the next item on the agenda was site visits, and indeed we touched that in the meeting. Mr. van Sprekelsen is very keen that it would be a site visit, and of course there'll no doubt be a site visit as part of the Section 37 application to which he's objecting. We've heard what Mr. Anderson has said, and I suspect Lord Sinclair as well would quite like us to come on to look at his site as well. So at some point, I think we'll need to find dates that are convenient, perhaps when convenient to all parties, when we're in the vicinity anyway. And I know Katrina is thinking about issues of site visit dates for her case. Katrina, you first. Do you have any thoughts on how we take forward site visits insofar as we can for today's purposes?
I had suggested that I would do my site inspections for the Section 37 during August and September, given that the actual oral sessions are in the winter months. Would that be too early to do the way leave site inspections? Or alternatively, we could wait until the winter, but weather-wise, it might be better to do them earlier as well.
Okay, ask Mr. Thompson first of all on that.
No, I think that period, it would be sensible to do everything at the same time if we could. And we could certainly include that in the list that's already been requested as possible destinations.
Okay. And for other landowners, would that sort of timescale, letting us come on your land at that time, within that sort of time frame, would that be okay?
I have no problem with that at all.
Yeah. Okay, thank you. And James?
Yeah, I don't have any problem with that at all.
That's okay. That's all fine. Good, thank you. So that's that site visits. I don't need to say very much. I don't think about other documents. It's really just mainly for the benefit of the landowners who, as I said at the beginning, are perhaps a bit less familiar with the processes here. Is once we have all the statements of case all in, which we have in some cases, and once we fix the kind of the hearing dates. The normal DPA practice would be to set sort of deadlines by which documents and witness statements called precognitions are lodged with us and indications of lists of witnesses. A precognition is basically a statement of the evidence that you intend to lead. And my practice in dealing with these sorts of applications is not really to look for statements from the landowners themselves, because their statement of case will say that. But if at the end of the day, when it gets to a hearing, either of you are considering leading your own witnesses, either witnesses to matters of fact, or whether they're expert witnesses with expertise in forestry or whatever might happen to be, we'll be setting deadlines that are related to the date of the hearing, so X number of weeks before the hearing, by which point you'll be required to indicate a list of the witnesses you intend to come along, and the evidence they would give, and lodge a statement by way of giving fair notice to us as reporters, but also to Mr. Thompson as to what their evidence is likely to be. Equally, if you're intending to rely on documentary evidence, which might be publicly available information such as planning documents, or it might be information that's less publicly known to the applicants, again, we'll set a deadline by which these documents require to be lodged. And the same will apply to SP for them as well. They'll equally have the same deadline by which they have to submit documents. And it would not normally be the case that we would look to be receiving any documents that come after that date. This again is intended to give fair notice to what the arguments actually are. There can be circumstances in which something was unable to be produced by the deadline, and so on cause shown, the process is flexible to make exceptions to that. But the intention when it comes to the hearing is to be in a position where we have all parties, and this helps the reporters as well. As I say, all parties will have all the documents, an indication of the evidence that's to be laid before them at a reasonable period ahead of the hearing. And for Mr. Thompson's sake, my preference, I know not all reporters are the same, is even for the less formal process of a hearing with no cross-examination and the like, I quite like to ask applicants to produce even a relatively short precognition, setting out the professional qualifications of those who will attend the hearing with you, and the areas of expertise that they will speak on, not least so I know who I can direct my questions to. So we would look to be having that. The hearing process itself would be, again, as informal and relaxed as it's possible to be in the circumstances. I think we have sent out to the landowners already an indication of DPA practice, and sets out the difference between hearings and public inquiries. The essential difference is the hearing is a structured discussion led by the reporters, and again led by me in this case as the lead reporter, where all the questions strictly formally go through me and are asked of principally the applicants, witnesses and lawyers, but it's a discussion with an agreed agenda fixed in advance to to explore all the areas of objection and the case that's made, because obviously the applicants need to justify what they're doing. They need to meet the test in the legislation. And that's different from a full public inquiry, which involves cross-examination and re-examination and the like. So it's more informal than that. But in order to make that efficient and effective, having an advance notice of the issues that are to be raised helps the reporters enormously and makes the process on the day itself work more smoothly. So it's really just so the landowners are both aware that when we get to the stage of fixing hearing dates, we'll be writing out with indications of what all those processes would be and would involve. But I don't know if either of you have any questions just on that explanation of the general process.
No, I've got no specific questions on that. The only thing that I would ask, because I mean it's clear, as I didn't receive an agenda, that I'm copied in on all of the correspondence, or the correspondence is sent to me, because I haven't received the agenda. I didn't receive a copy of Murray Thompson's submission directly from the from Laura Walker, I think it was. So I would ask, please, that I am included on the circulation list.
Yeah, very happy to do that. That's absolutely no problem. And James?
No, I'm good. It's all good. No problem.
And anything from the applicants?
No, it's all clear. Thank you.
That's all fine. And the last item I had on the agenda was a very brief thing, really, just on closing submissions and next steps. The only thing I wanted to say under that is that when we get to the hearing stage, for where there is a separate hearing, my practice is not to ask for closing submissions to be submitted on the day of the hearing itself. I normally give parties 7 days, and so just in case anybody is wondering and worrying about whether they're going to be expected to summarise the outcome of the hearing on the hoof as they go, my preference is to give a little bit of time, a little bit of a warning, and in that period, the purpose of a closing submission is just to draw together in a coherent way a summary of what your case is. It will not be open to introduce new evidence in a closing submission. It's a summary of your case based on the evidence that's laid, rather than introducing new evidence. But none of you will be expected to do that on the day itself. And next steps beyond that is myself and Katrina will have to work through how we package our respective reports on all the issues concerned in order to give a kind of coherent package to ministers to consider all the various strands that, as you mentioned at the beginning, Mr Thompson, different processes that are underway in relation to all these matters. And that's what we'll do once we've finished all the various parts of oral and other process for these matters. So that was really all that I had for today's meeting. As I say, I'll write this up and get that issued as soon as I can. Katrina, I don't know, is there anything else you wanted to say to parties while we're all here?
I think that's a no.
But it's not playing. No, I was just saying that no, everything's been covered. That's fine. Thank you.
Now it's me that's in mute. Mr Thompson, anything more before we close?
No, nothing further from me, thanks.
Yeah, and Lord Sinclair?
No, other than will you formally assist the in terms of the assisting of our
Yep.
Yes.
Thank you. Will do. And Mr Anderson?
Thank you.
No, I'm fine, thank you. It's all good.
That's all fine. Okay, well, thanks very much for your participation today. So I'll close the meeting and write out, as I say, as soon as I can write out a note for that, and we'll take other matters from there. Okay, thanks very much.
Thank you very much.
Thanks.
Thank you.
Thanks. Cheers. Bye-bye.